So I'm going to ask you, well, actually, you're going to go first in terms of your closing. So let me ask Mr. Brockler about the objection that he has to your PowerPoint presentation. Mr. Brockler? I do not.
Your Honor, I can just approach with the one and we'll talk about it.
Okay.
If you don't mind.
I don't mind. Thank you.
Your Honor, I've been provided a copy of this proposed PowerPoint presentation by Ms. Brady, and I think I'd mentioned before we'd had an opportunity to go over it. I think changes were made based on some concerns that I'd voiced to her, and I appreciate that. The slide that I gave the court is one, and I guess I should start by saying if mimicry is the best form of a compliment, then this is what I think the defense has done here, is that when the court ordered us to turn over the electronic copies of our closing PowerPoints, the defense, and it tactically smart, took a whole bunch of slides where I referenced Dr. Metzner and incorporated them into this closing PowerPoint. I don't have a problem with that, except this slide. This was a slide that I had placed into the closing to capture the sentiment testified to by Dr. Metzner about sanity. And the court will recall, I asked him several times about the different steps, and he said he was highly confident. He did not render that type of an opinion in this particular case, and the court may recall that on Monday, instead, there was an attempt to say, do you have any doubt? We approached. It was very quickly resolved. And then Ms. Brady changed her question to a reasonable degree of psychiatric certainty or something like that. So my objection is this misstates his testimony, and I think Ms. Brady may even agree with that. To just clarify, though, from the from the guilt phase, his testimony was specifically that, and this was in his report too, that he was highly confident that the defendant did not suffer from a mental disease or defect that prevented him from having the capacity to form the intent to do the other two prongs that we talked about. That's my objection.
All right, Ms. Brady.
Your Honor, my response is that Dr. Metzner testified in the first trial that Mr. Holmes did suffer from a mental disease or defect, excuse me, specifically schizoaffective disorder, but that it did not render him incapable of distinguishing between right and wrong. So the highly confident slide that I intend to use goes to his finding of mental disease or defect, that detailed, done well, highly confident, all of that relates to the issue of mental illness, not to the, obviously, the distinguishing between right and wrong. So I don't think it misstates his evidence. He was highly confident that Mr. Holmes had a mental disease or defect, and he testified to that in the first trial.
Do you have a specific reference to his testimony where he said that? My recollection is that there was a question asked about whether he had any doubt, and I think there was an objection by Mr. King. I sustained the objection because of the concern about using the word doubt, which of course is used in the term beyond a reasonable doubt. And based on the bench conference that was held, Mr. Brockler asked, are you confident in your opinion about sanity? And he was specific about sanity. At least that's my recollection. And then the answer was that he was highly confident in his opinion that the defendant was not insane at the time of the commission of the act. I don't recall him offering that opinion with respect to anything else. What I remember those words with respect to specifically the issue of insanity, and I remember Dr. Reed offering a similar opinion, again, on the issue of insanity. But I may not be remembering something that he said. So do you have a reference to something that he said with respect to just mental illness in general?
Can I have a moment?
Yes.
Thank you. Your Honor, I don't think it changes my presentation at all to take that out. I don't think it's worth fighting over.
Okay, thank you. All right, the objection is withdrawn then. So, not the objection, actually the slide is going to be withdrawn. So that makes the objection moot. Is that all you have, Mr. Bruckler?
Yes, sir.
All right, thank you. All right, Ms. Brady? Mr. Bruckler, do you want this back?
If I could, sir, what I'd like to do is a copy of my slides that I had given Ms. Brady to go along with.
I'll trade you. Okay, Ms. Brady.
Your Honor, as I stated right before break, I have a category of objections, and that is to any slide that Mr. Brockler uses which pulls out statements made by Mr. Holmes in any of his writings, or to statements that Mr. Holmes made to any of the court-appointed experts. As the court knows, from the statute 16-8-107, prosecution can only use the information they learned from the first time from those court-appointed examinations. Those statements can only be used to prove mitigation or absence of mitigation. And so I would ask that each time he uses a statement that the mitigation that it is going to rebut is stated for the record.
Mr. Bruckler?
Moment to strap on the wireless. I didn't.
Yeah, you bet.
Your Honor, these pages are numbered, although the slides aren't. I couldn't figure out how to do that. I should say as an initial matter, while we've been sitting here going through the instructions and the defense theory of mitigation, I have made additional changes in terms of some of the order of these. There are only a few substantive changes. I have printed those, and the court will see on the back end there's about 7 slides or so I added in. I gave Ms. Brady copies of those. And so what I'd ask of the court is permission to, when we're done going through this, after I make this, the opportunity to print for Ms. Brady one more copy, just to have her look at it one more time to make sure that neither of us have made a mistake about what we think is going to be presented. And I presume hers is unchanged because she's just pulling out a slide. The first place I have, Your Honor, that there is use of the defendant's statements from the notebook I have on page 6. It appears to me to be the second slide on the left-hand side down.
Yes.
This is a section, and I should tell the court, I've recaptioned this based on the instructions that the court gave under reference to not just the delusion, but also capacity to conform his conduct to the law, which they have claimed he is impaired on. These are all indications, and they're surrounded by them, of ways in which it shows he suffers from no impairment to conform himself to the law, including this particular statement where he actually says,
when I'm in therapy, it was my goal to not give incriminating statements. That was the purpose of that one.
So that goes to one of the mitigating factors in the theory of mitigation instruction. Is that what you're saying? Or in the statutory mitigation
I'm sorry.
instruction?
Yes, sir. That actually goes to the statutory mitigation.
Okay.
Your Honor, while we're on page 6, the bottom right-hand slide, there's a date highlighted. Mr. Brockler took it out.
And let me clarify that, Ms. Brady. I'm sorry. I took out the box that has the highlight. I couldn't figure out how to unhighlight it, so I just deleted it. So now it looks just like it does now, Judge, except the only thing that it says there is petition for in-state tuition.
Okay.
So there's no yellow highlight on anything?
No,
Great.
not on that.
Great.
All right. Ms. Brady, are you satisfied with the offer of proof then with respect to that particular slide that Mr. Brockler just talked about, which comes from the notebook?
Your Honor, I'll maintain my objection and let the court rule.
Okay. All right, I agree with Mr. Brockler that that goes to the statutory mitigator that he mentioned, and of course, the jury is being instructed that they can consider evidence that was admitted in relation to the defendant's plea of not guilty by reason of insanity, only for the limited purpose of considering the existence or absence of a mitigating factor. So, Mr. Brockler, what else?
Yes, sir. On page 11.
Now, let me just make sure. Ms. Brady, are you asking that he make an offer of proof with respect to each slide that has the defendant's statements that are protected under the statute that you mentioned, or are you asking that every time he mentions it in his closing argument that he indicate during his argument what mitigating factor that goes to?
I'm asking that he make an offer of proof for each slide as to which mitigator.
Okay.
So I show on page 9, we have a quote to Dr. Reed. Bottom left.
Oh, yes, thank you. I missed that one.
All right.
Your Honor, this too falls under the ability to, any impairment of his capacity to conform himself to the law. The court will recall that this statement, in the context of the different slides around it, was made because the defendant anticipated that the law would arrive, see what he had done as wrong, and he was going to attempt to flee the law. And that was the basis for not only acquiring the Roadstars, but his subsequent statement to Dr. Reed, in case I had to get away in a pursuit. I think it goes to his capacity to appreciate and conform himself to the law.
I agree. I don't know if this slide is missing a couple of words. It just says, in case I had to get away, pursuit. And maybe that's the quote, but okay. What's next?
Your Honor, I show on page 10, the bottom right-hand slide is from a message that Mr. Holmes sent that talks about being evil, and I would object to using the term evil, even if it's from Mr. Holmes during this capital sentencing hearing.
All right, this is a slide that appears to be a copy of the March 25, 2012 G-chat between the defendant and his then girlfriend or former girlfriend, Ms. Datta, Gargi Datta. Mr. Brockler?
Yeah, Your Honor, and I have put a slide directly in front of this that, maybe you already see it, that says impaired appreciation for wrongfulness, which, as the court knows, is something that Dr. Metzner testified to. This speaks directly to that he does know what he's thinking and planning is wrong.
And so your position is that this goes to what aggravator?
Well,
or what mitigator?
It specifically addresses the mitigator related to his impairment in his capacity to conform himself to the law and and appreciate the wrongfulness of his conduct.
It also goes, I think, to the mitigator that talks about mental illness, and this is part of what Dr. Metzner talked about. So the objection is overruled with respect to this one as well. What's next?
Page 11, bottom right slide.
All right, this appears to come from the notebook.
Your Honor, this is going to sound wacky. I'm sorry to interrupt, but on that same page, Ms. Brady did not address the issue of the Vicodin. And I know that Vicodin was something that the defendant had at one point told mental health providers, and I think it showed up in evidence somewhere else, but that too might be perceived later on as something that was told to mental health providers as part of the NGRI investigation. And I wanted to make clear that that too much like the willingness and intent to flee and getting the first aid dressing, is all meant to address his appreciation that the law would attempt to stop him and likely use injurious or lethal force to do so.
All right. Ms. Brady, what you're on page 11?
Bottom right-hand side appears to be from the notebook.
Mr. Brockler?
Same argument, Your Honor, in that it goes directly to the mitigators that speak to his capacity to appreciate the wrongfulness of his conduct.
Hold on a second.
And Your Honor, that should be statutory mitigator number 2.
Yes, and again, this is the one that's dealing with mental illness, and it reads as follows. The defendant's capacity to appreciate wrongfulness of the defendant's conduct or to conform the defendant's conduct to the requirements of law was significantly impaired, but not so impaired as to constitute a defense to prosecution. So it's the same mitigating factor, statutory mitigating factor that we've been talking about. And it's just, it's one, but this is where the mental illness issue comes up. And I agree with Mr. Brockler. So let's go on to the next one, please.
Page 12. And there are
Yes.
4 slides there that appear to be writings by Mr. Holmes. And also I'd object to the slide that says selfish. Object under 401 and 403, and that the prosecution shouldn't use pejorative terms in describing the defendant in their closing argument.
Mr. Brockler, are you using selfish in the context of choices, or are those two separate things?
Those are related, Your Honor, but the court will recall it also applies to the motive in this case. That was a word that Dr. Metzner agreed to in his testimony as to describe, I guess, the delusion or the motive that the defendant had. That's how I intend to use it.
Okay. And what about the other slides?
So the 2 slides above, Judge, one on the left, cruel twists of fate, also go to his capacity to appreciate the wrongfulness of his conduct. And the one next to it, research firearms laws and mental illness, also go to his capacity to conform himself to the law, showing certainly a capacity and willingness to research the law prior to engaging in this homicidal conduct.
And what about the 2 bottom ones?
The 2 bottom ones speak to the mental illness component that I think appears in paragraph 3 of the non-statutory mitigators that say, but for this mental illness, none of this would have happened. And here he makes it clear in his own hand in this notebook that he does things because he chooses to do them. I think it addresses that specifically.
Okay. I don't have any concerns about any of those. The selfish, that is the word that Dr. Metzner used, and Dr. Metzner was called by the defense, and I think it's an appropriate slide. So I'm not concerned under Rule 401 or under Rule 403. I don't see an unfair prejudice or any risk of unfair prejudice, and I don't, to the extent that any risk exists, it does not substantially outweigh the probative value of the evidence or the use of the term. So what's next, Ms. Brady?
Page 14.
Okay.
Two slides that are writings by Mr. Holmes.
And are these both from the notebook again?
Yes, sir.
All right, Mr. Brockler?
Sir, the court will recall that paragraph 3 of the non-statutory mitigators speaks specifically to the mental illness and his delusion that was defined by Dr. Metzner on Monday as being the sole cause of what happened, and that but for that, these events wouldn't have happened. There are a couple different but-fors the court sees as it goes through here where I'm rebutting that or saying that's not a mitigator because there are other motives unrelated to this, whatever's called a delusion or his motive for doing it. One of them is the fact that he has a broken heart and he was rejected from his first love relationship. That is captured by these two, and actually if the court looks, the very next page, the one that says love gone on the bottom right-hand corner of 14 carries over. The rest of that quote is on the upper left-hand corner of 15, and that's what it addresses.
You're saying there are other reasons for the crime than mental, and other explanations for the crime other than mental illness.
Yes, sir.
All right, I agree.
Your Honor, since it all carries over onto page 16, I assume it's the same response by Mr. Brockler and the same ruling by the court.
Mr. Brockler? Does this go again to rebutting the mitigator related to the mental illness being the cause and the but-for cause of the crimes?
It does.
Okay, and so same ruling. Go ahead.
I'm sorry, I forgot. I can't remember if I told you this one, Ms. Brady, and I'm sorry to address Ms. Brady in front of you, Your Honor, but on page 17, after the two quotes at the top by Dr. Reed that deals with hatred, I have added a slide while we sat here that has the phrase, "I hate everybody," and it's attributed to Dr. Woodcock, which is testimony that he provided. It is also offered for that same purpose, and that's to address the third non-statutory mitigator.
All right, Ms. Brady, what else?
Page 18, I think it still continues on to page 18.
Is that right, Mr. Brockler?
Yes, sir.
All right, same ruling. What else?
Page 19, the three sides with handwriting on them.
Mr. Brockler?
One of the other motivations for the defendant to commit this crime is an interest in gaining some notoriety, and the court will recall that showed up not only in the guilt phase, but it was addressed by the defense with Dr. Metzner on Monday, who downplayed it and diminished it as a motive, thus leading to the third non-statutory mitigator. This is an attempt to address that by using the defendant's language from the notebook to highlight that his motives were more than just mental illness or increasing his self-worth.
So again, it goes to providing an explanation that's different than mental illness for the crimes.
Yes, sir.
And showing that there is a different cause for the crimes.
Yes, sir. That's right. Thank you.
All right, same ruling. I agree that these are appropriate. Let me just say, by the way, that you should be careful, Mr. Brockler, in your argument to make it clear to the jury that you're only using this evidence for the limited purpose that the court is instructing the jury it can use it for, all right? And you don't have to repeat it every single time. It's fine with me if you say it in advance, but I want to make sure the jury is not at any point confused as to the limited use of the evidence that we're talking about. All right, Ms. Brady?
Pages 20, 21, and 22, all of the statements made to Dr. Metzner and Dr. Reed.
Mr. Brockler?
Same response, Your Honor.
Same ruling. Ms. Brady?
Page 23, the middle slide on the left, I would again object to kill box. I think I made that objection, I believe, for Mr. Orman's opening, although his might have been kill zone, but I object under the same grounds to kill box.
Mr. Brockler?
Your Honor, this is a slide that I took from the closing of the guilt phase of the trial, and I think we'd had an objection then and the court overruled it. I don't think it's improper. I think it's fair argument given the evidence about how this ambush was set up.
I overruled it in phase one, at the end of phase one, and the reason I overruled it at that time, what I overruled was something similar, by the way. It was, I think, a kill zone or something along those lines. I allowed kill box at the end of the trial, and I distinguished it, or I explained at the end of phase one why I was sustaining the objection to kill zone, knowing that I had overruled the objection to kill box. And it wasn't because of the difference between zone and box. it was because of the juncture in the proceedings at which it was used. I didn't feel it was appropriate at the end of phase one, where the prosecution's burden of proof was simply to establish whether there was at least one aggravator, and they had to establish it beyond a reasonable doubt. And I didn't think it was necessary. The question is it appropriate here, where the jury has to determine if the mitigating factors outweigh the aggravating factors? Let me think about it for a moment. Ms. Brady, what do you believe the risk is with respect to that slide?
Well, Your Honor, I think the term kill box is sort of a statement of personal opinion about what someone might think that was. I mean, you can call it a shooting in a theater, and that factually describes what it was, but to call it a killing box or a killing zone, I think, is a statement of personal opinion.
I think it's argument, so I'll overrule it. Again, I distinguish this from phase one, because in phase one, there was no evidence presented. It was just argument, and it was just a matter of whether the jury was convinced that the evidence presented in the trial established the aggravating factors that people had asserted. So I don't see what the risk for prejudice, much less unfair prejudice, is. I don't think there's one. It's argument. The jury will understand its argument. The jury has been instructed that counsel's closing arguments are not evidence, that they're only arguments, and I think it's just a way of describing it. And I think it goes to the prosecution's description based on the evidence, based on what the evidence, based on the evidence that they presented. So I'll overrule the objection. What else?
Pages 24 and 27 both use the phrase "his victims," and I believe I've objected to that before too, and I believe that the court overruled it, but I'll make the same objection here.
Okay, same ruling. By the way, let me go back to kill box. That goes not only to the aggravator of lying in wait or from ambush, which the jury now has to figure out how much weight it deserves and has to weigh it against the mitigating factors that that the jury may find. But it also goes to, I think it's, as Ms. Brady, as I infer from the argument from Ms. Brady, as to what someone might think in terms of what happened here, what the defendant did here. So it goes again to the mental aspect of the incident. With respect to his victims, same ruling I made before. At this juncture, the jury has found the defendant guilty of all the crimes that were charged, and I don't see anything improper about saying his victims. I don't see anything prejudicial about that, so the objection is overruled. What else, Ms. Brady?
On our page 30, the middle photograph on the left is that weapon with the blood spatter and the pink flip-flop, and I would make the same objection I made earlier to that slide.
Same ruling as before. This is where the weapon was found, and yes, there's some blood in here, and yes, there's a sandal in here, but again, the jury has found the defendant guilty now of murdering 12 people, and that's what's before them. That's what we're talking about. It's the aggravating factors and the mitigating factors, and I don't think it's a picture that will evoke strong emotions, especially given the other graphic evidence that has been introduced in the trial and that the jury has viewed. So the objection, again, under Rule 401 is overruled because it has probative value, and it is overruled under 403 because the probative value is not substantially outweighed by the danger for unfair prejudice.
And Your Honor, last, starting on page 31, begin a series of pictures of injuries, and we've previously litigated those photographs to the court, and we would renew our objection to those photographs that they evoke sympathy and are unnecessarily prejudicial, especially at this capital phase, and we would renew those objections to the photographs of the injuries, and if Mr. Brockler intends to show any autopsy photographs or crime scene video or anything like that, we'd lodge the same objections.
Mr. Brockler?
Your Honor, as to the photographs, these have all been admitted into evidence, and the court can tell by the volume of them there is no opportunity to linger on these, nor do I intend to. This is an intent to highlight the grave risk of death created by the manner in which the defendant acted in the theater, and so I'll be zipping through these quickly. In terms of the autopsy photographs, I don't intend to display any. As far as the crime scene video, I don't intend to display any. I should put on the record, I've told Ms. Brady that consistent with how I conducted the opening and the guilt phase, I brought out the pictures of the deceased, the 10 deceased where they were found in the theater. I intend to, with the court's permission, at the appropriate times, walk outside the view of the camera and again to display those to the jury. Other than that, there are no additional photos or videos I intend to show.
All right, the photos have been admitted, so I incorporate by reference the record I have made before, which includes my rulings. And I appreciate that Mr. Brockler is not intending to dwell on these pictures. But these pictures go to the grave risk of death created to people other than the 12 deceased victims, and that's one of the aggravating factors. Ms. Brady, what else do you have?
Your Honor, if I can just supplement my record by citing Mr. Holmes's right to a fair trial, due process, fair and reliable sentencing hearing, fair and impartial jury under the 5th, 6th, 8th, and 14th Amendment, Article 2, Section 16, 18, 20, and 25. Thank you.
Mr. Brockler?
I just wanted to make sure that the court is has been able to review that addendum that I attached, and that your rulings have covered that. Those are the additional, I think, 7 slides that go to the defendant's varying descriptions of his delusion and human capital, and I intend to insert them into the presentation at a predictable place where it talks about it. But those two would be offered to address the mitigators of the mental illness and whether it was the direct and sole cause of this event.
All right, give me just a moment, please.
Yes, sir.
In terms of the pictures, I understand that these are graphic pictures, but this is a graphic crime, and it is impossible to try this case without showing the jury some graphic photographs. That's in large part as a result of the nature of the crimes. So that doesn't mean that the defendant is being deprived of his right to a fair trial. I have tried to do my best to protect the defendant's right to a fair trial throughout, and I believe that the same applies now in these proceedings. But these pictures are, in my view, appropriate, and I'm not concerned that they are going to evoke such a strong emotion from the jury that the jury will not exercise its reasoned moral judgment, or that each juror will not exercise his or her reasoned moral judgment and instead will make decisions based on emotional or for emotional reasons or for some other arbitrary reasons. So in terms of the additional slides, Ms. Brady, did you have anything with respect to those, or do you have any other objections that you want me to address?
The new slides, there are some quotes made to Dr. Metzner and Dr. Reed, and I would make the same objections to those slides as well.
The same objections in terms of asking for an offer of proof?
Yes.
All right, Mr. Brockler?
Same response, Your Honor. Same response, Your Honor. I think it directly addresses the mental health mitigator that was placed throughout the non-statutory mitigators, specifically, though, highlighted in number 3.
All right. Is there any specific slide, Ms. Brady, that you think I need to address?
No, Your Honor.
All right. I agree with Mr. Brockler. So the objections overruled with respect to these slides. And obviously, Ms. Brady, if at any time you believe Mr. Brockler is making an argument that's improper, whether it's related to this specific point or any other point, you need to make an objection, and I'll rule on the objection. But what I have understood is that you're right now making preliminary objections and asking the prosecution to simply make an offer of proof. The prosecution has made an offer of proof, and I am satisfied with that offer of proof.
And so I won't object when these slides are shown, since
Okay.
I've made my objection at this point.
All right, that's fine. But if at any point one of these slides is shown and you believe that he has gone away from the offer of proof that he has made, then you need to object at that point. You have not preserved your record with respect to those, and there's not a standing objection. So if at any point you think, Judge, he's not sticking to his offer of proof, or this is not related to the mitigator that he indicated to the court, but this is something not related to any mitigator at all, or perhaps a different mitigator, then make an objection and I'll address it, okay?
Yes.
All right, are there any other objections that I need to address on behalf of the defense, Ms. Brady?
No, Your Honor, I did intend to use the chart that we used during jury selection just to point out that we're at phase 2 and sort of take them back to how that process works, and if that's okay with the court, I will use that.
I don't have a problem with it. Does the prosecution have an objection to that?
That makes it tough, Your Honor. When you tell me you don't have a problem with it, I guess I don't either.
Okay, all right.
I want to be on the winning team.
All right. And by the way, for the record, the defense had attempted to use a slide of something similar to this in opening statements. As it turned out, it became a moot issue because the equipment didn't work. But I had sustained an objection to that slide. The slide that was included in Ms. Hicks's opening statement was not the same board that's here in the courtroom. So I don't have a problem with this one. I did have a problem with that one. And I think this one is the one that was used during voir dire, and I think it's fine to use it in closing argument. So without objection, I will allow it. Mr. Brockler, what else do you have?
Just in terms of logistics, Your Honor, I know the court is just finalizing these instructions now, or has finalized them. If the court would grant me the opportunity to do 2 things. One is to incorporate a couple portions of the numbered instructions into this presentation, print it, provide it to Ms. Brady, so if there's any other change that I've made since we've been in this courtroom this morning, that she has at least an opportunity to make it known to the court that she has an objection.
That's fine. How long do you need? 60 seconds?
That feels short.
How long would you like?
Well, Your Honor, as soon as we get that finalized copy from the court in an electronic version, I can incorporate them into that. I would say once we get that, I would need 15 minutes, maybe 20 minutes tops. And that's for me. Ms. Brady, how much time? I guess Ms. Brady needs to tell you how much time she needs to flip through them.
Ms. Brady, how much time would you like?
5 minutes?
Well, let's see if we can shoot for 15 minutes. But if you need 20, Mr. Brockler, I'll give you 20. So do the best you can. I'm going to have my staff send those to you, both of you, electronically, and then we'll check with you before I come out and make sure you're both ready. Remember that it's going to take me probably more than an hour to read these instructions. It'll probably take me more than an hour just to read the 2 that you provided this morning, Ms. Nelson. So it'll take me quite a while. So, you might be at counsel's table, still be finalizing things, and then we'll take a break after that. So the plan is I'm going to bring the jury out. I'm going to read all the instructions. We're going to take a break, another break at that point, and then we'll proceed with closing arguments, starting with Ms. Brady and proceeding after that with Mr. Brockler. So, Mr. Brockler, you probably won't be making your closing argument for a while, but I know that you want to give a copy to Ms. Brady, and I appreciate you doing that. So we'll take a 15-minute break or so, okay?
Thank you, Your Honor.
All right.
I think Ms. Nelson wants to say something.
Ms. Nelson?
I just wanted to alert the court to 2 discrepancies with exhibit numbers. As we were going over the exhibit list that was provided by your staff via email last night, we noticed that we had accidentally assigned the same number to two different exhibits, and that
Okay.
happened twice. So we'd like to just propose that we renumber the overlapping exhibits.
That's fine. How
So-
do you want to renumber them?
The first one. Oh, we could add an A, or we can add an A, actually. That might make it easier.
That's fine.
So number 392, there was a video clip that was introduced through Mr. Holmes that was first given the number 392. And then yesterday, Mrs. Holmes testified about a school report was admitted through Mrs. Holmes that was also given 392. So if we could add an A to the second one.
To the school report?
Yes.
Okay, we'll do that.
And then 394 was introduced through Mr. Holmes as a CD of the voicemails that he left for his son. And then yesterday, Arlene Holmes admitted through Arlene Holmes was a book that Mr. Holmes had made as a child called the Holmes Family Book. And that was also given the number 394. So if we could make that one 394A.
We'll make the Holmes family book 394A.
Thank you.
Okay. I'm assuming there's no objection from the people, right?
No, no.
Okay, great. All right, does anybody have anything else before I step down? Mr. Bruckler, do you want your slides back?
I'll get them back from Your Honor. One final thing, and this is, I guess, somewhat in limine of the argument. The court will recall that at the opening, the 2 to 3 minute openings that we had for this phase, Ms. Higgs ended on something along the lines of, "We don't put people to death who are mentally ill," or words to that effect. And I'd like to voice an objection to that in advance of it potentially being made by the defense during their argument. At this phase is not about the decision to impose death or life in as much as it is about weighing, and the weight may lead to a conclusion, but I just think that's an inappropriate argument, and I'd like to get it out now instead of doing it in the middle of Ms. Brady's or at the end of Ms. Brady's argument.
Ms. Brady?
Appropriate argument to say that if a juror thinks that the mental illness is the kind of mitigation that outweighs the aggravation, or if they think that a mentally ill person should not be put to death, then for them, mitigation outweighs aggravation. And if they find themselves in that position, they need to so state that the mental illness mitigation outweighs the aggravation because they don't think a mentally ill man should be put to death. I think that's a fair argument.
I think I followed you with respect to the first part of that. The second part, I'm not sure that I agree, and I don't want them to be confused as to the state of the law. So, I mean, if you want to say that, or argue that if a juror thinks that the mental illness is the kind of mitigation that outweighs the aggravation, then they should so state in their verdict in phase 2, and that also means that they don't believe that the person should be sentenced to death. I think that's fine. But the second part of that was, it sounded like almost the reverse of that, but not quite. And what you said was that if a juror thinks that a mentally ill person should not be put to death, then for them mitigation outweighs aggravation. I don't know that that's necessarily true. And I don't know that it's appropriate for a juror to decide, well, for example, in this case, I think the mitigation does not outweigh aggravation, but I came into the proceedings with the idea that anyone mentally ill should never be put to death, so I'm going to vote in a different way than what I believe the evidence warrants me voting. That's where I think you could get confusing, and so if you want to say it the way you said it the first time, I don't have a problem with it, and I think it's fine even though it's phase 2 if you want to refer to the ultimate outcome. This is different because we're doing it in 3 parts, and even though right now they're not going to be deciding the ultimate outcome, in a way they are making a decision that could decide the ultimate outcome. So I think it's fair, but you should be careful in how you phrase it so as not to be inconsistent with my instructions of law. Does that make sense?
It does, Your Honor. I would just state that if mitigation is anything any one juror can consider to impose a life sentence or not impose a death sentence, I think their view on the use of the death penalty for mentally ill people could be mitigation. That could be a mitigator for one of the jurors. And if for them mitigation is not executing a seriously mentally ill person, they should be able to use that reason and weigh that against the aggravation. So I would just make that record that I think I should be allowed to argue that, but I understand if the court orders me to do otherwise.
Do the people want to be heard on that? Yeah.
Your Honor, I agree with what the court had said previously, and I do share the concern, and that is that a blanket statement about mental illness disqualifying someone for death maybe has a role in the third phase, and I'm not conceding that. But this is such a personal, individual weighing. I do think the court's suggestion to Ms. Brady is the one that I would adopt.
Ms. Brady, I don't want to rule in a vacuum. I'm just telling you that you should be careful in how you phrase it, because right now you made a couple of different statements. One of them did not cause me concern. The other one did. I'm not issuing a ruling right now as to what you can and cannot say, but you may get an objection, and if you get an objection, I'll have to call you to the bench, and then I'll have to hear you out in terms of what exactly you said. I just want to be careful that the jury is not told something that's different in the instructions. Obviously, this isn't a referendum on whether mentally ill people should be subject to the death penalty. That's not what the issue is. That's not what the jury is going to be deciding. This is a question about the appropriate sentence for this defendant. Now, mental illness is a big factor in this, but you have to be careful not to confuse the two, because I think they're very different. That's all I'm saying, okay? All right. Okay, I'm going to take a recess. Mr. Brockler, I'll give my staff your copies of your slides, and they'll give them back to you. All right, the court will be in recess. Thanks.
All rise.